Hello, and thank you for watching. My name is Bradford Roberts, Principal Broker, Founder, and Owner of TR Realty in the Las Vegas area. After watching this video, please be sure to like it as well as subscribe to our YouTube channel. Download the pertinent handouts for this video by clicking the link in the comments below. Now let's get started. Now it's time for us to get into the rental paperwork. So I'd like to begin by going over the paperwork that is required on the lessee's side of the transaction. By the way, it's not leasee, it's lessee, which is another word for a tenant, right? The person who is renting the property. So the first thing is the duties owed. And I understand that there's some controversy with the real estate division regarding doing duties owed with a rental. We're going to break that down a little bit later. But for now, I want my agents to go ahead and get a duties owed when they're working with a rental customer. I go over the duties owed in Class 3 video, in the Class 3 video series, so I'm not going to be going over it again in this video series, other than to let you know that I do require that when you're working with a tenant. The second required form, maybe, caveat there, would be the consent to act. So the consent to act is only required if you also are representing the landlord, the lessor. So if you're going to represent the lessor and the lessee, which is perfectly legal and allowed at TR Realty, then you're going to need that consent to act. You're going to need that written permission from both sides that allow that dual agency concept. And again, I cover that form in great detail. That's going to be in my Class 4 video series, so I'm not going to cover that form right now, other than to let you know that if you are working both sides in a rental transaction, we do require the consent to act. The third form that we require on the lessee's side of a rental transaction is going to be the TR Realty Lessee's Disclosure. Now that is a form that is not covered in any other video series, so we're going to spend some time on it right now. Please pull out the TR Realty Lessee's Disclosure. And it says at the top of the form, this document shall serve as a list of important disclosures to you, our customer. However, this is not intended to be inclusive or exhaustive. TR Realty believes these disclosures are important while making a decision to lease real estate. This document does not obligate you in any way. Rather, TR Realty believes you have the right to be informed. And this is quite a lengthy document. I want to go through it with you because I feel it's really, really important. And this is well, to be very candid with you, it's a layer of protection for you and for me. Most companies have some variation on a form like this, some sort of a disclosure form. This is our version. It is absolutely mandatory in a rental transaction. And if you are an agent with TR Realty watching this video right now, you will find that TR Realty's lessee's disclosure is a mandatory document on your closing checklist. So let's get into it. Paragraph 1 talks about the right to legal counsel. You always have the right to consult with an attorney of your own choosing and at your own expense, etc. That's really important that the public knows. They always have the right to talk to an attorney before, during, or after any type of transaction. And that is so important that we put separate initials after that paragraph. When you turn this in as part of your rental file, we are absolutely looking for the customers to initial right there after paragraph 1. Paragraph 2 is the statute of frauds, which means basically for something to be enforceable in the courts, it has to be in writing. Number 3 talks about the definition of an effective lease. Whenever we use the word effective, which is, in my opinion, not only better to use, but more accurate to use than executed. I'm not an attorney, but I have a totally different understanding of the word executed than I have of the word effectuated or effective. So whenever we use that word, we're talking about a contract that has been signed by the parties and delivered to the parties. We need both the signatures and the component of delivery to have an effective contract of any sort. And in this particular case, we're talking about an effective lease. Paragraph 4 talks about fees, specifically that any application fees are typically non-refundable. Paragraph 5 is fair housing. I'm sure most of you watching this video have watched a lot of my videos by now, and you know that fair housing is not an option at TR Realty. We absolutely mandate strict adherence to all fair housing laws and amendments at TR Realty. It's not a joke to us at all, and that's why at the end of this paragraph it says any alleged violations will not be tolerated and must be reported to the broker immediately. Absolutely. Off with your head. Paragraph 6 is what we call a relationship disclosure. In Nevada, we refer to that as a duties owed. Other states call it something different. It is generically known as a relationship disclosure. Paragraph 7 is a vendor disclosure, which basically says that the public is not compelled to use the vendors that we recommend. They can go out there and they can hire any of their own vendors. Paragraph 8 is a section on fraud. We are warning the public about cyber crimes and wire fraud and things of that nature. And you can see paragraph 8 is so powerful that it actually has 2 separate sets of initials that we do require the tenants, the prospective tenants, to initial. Paragraph 9 talks about hazardous substances. 10 talks about mold. 11, renovations, additions, and pools. 12 is the conservation easement. I get into that quite a bit in the Class 3 video series about the conservation easement. There's a website here in paragraph 12 that you can visit and you can learn more about a conservation easement, but it is something we feel that the tenant needs to know prior to signing a lease. Paragraph 13 talks about school districts and how the prospective tenant needs to check school districts by themselves and not rely on us for that kind of information. The same goes with 14, which is about sex offenders. Paragraph 15 talks about common interest communities, that if you are renting a property inside of a homeowners association or a condo association, that you are required to follow the rules. You're responsible for knowing the rules, and if there's any fines imposed because of a breach of those rules, that tenant is going to be held accountable for that. Paragraph 16 talks about age-qualified communities, basically who can live in an age-qualified community. They're going to have to check directly with the association to see if they qualify. And paragraph 17 gets into some details about pets. And then it says at the end of this disclosure, it says, you hereby acknowledge your TR Realty associate has explained these disclosures to you, our customer. In the event any part of this document requires additional explanation, or you should want additional assistance understanding any part of this document, please ask your TR Realty associate or seek assistance from an independent source. Your signature below indicates you have read and understand this document, and you acknowledge receipt of it. Please keep a copy of this disclosure for your records. You can see signature lines as well as places to date. Don't forget the initials all the way down the bottom. And allow me to repeat, in a rental transaction at TR Realty, this TR Realty lessee's disclosure is absolutely mandatory and should be done immediately following the signing of the duties owed. In other words, this needs to be presented and signed way before the prospective tenant is thinking about submitting an application, certainly much less signing a lease for a property. So that's the TR Realty lessee's disclosure. It is the third required document on the lessee's side of the paperwork list. Let's go on to number 4, which is another form that I've not covered in any other video series, so we're going to take a look at it right now, and that is the rental application. TR Realty uses the standard rental application that's provided to us by LVR. I know that some brokers like to create their own application, or In some cases, they're using an application that was provided by their software company. But we use the standard application in Transaction Desk on a LVR because we believe it makes us more competitive. It's a form that people can easily recognize and understand. And I'd like to begin going over this by starting with the box section on the top right of page 1, where it says required to submit. You see the very first thing there is the non-refundable application fee. Non-refundable because application fees at TR Realty and at most companies are non-refundable. Some people think that if they pay an application fee and they don't get the property, they should get their application fee back. Actually, it's called an application fee because the fee is for applying. And real estate companies like TR Realty, they incur a hard cost when they process someone's background check. So that's why application fees are typically non-refundable. And then there's a place to put in a holding fee, which we don't really work with much at TR Realty, but it is always up to the property manager or courtesy listing agent if they wish. And then evidenced by, we put in the method of payment, whether it's a money order or credit card or whatever. We don't take cash at TR Realty. And then if someone brings this application in person, in other words, a physical application, we actually require them to initial next to this box because we don't want any issue later with someone saying, I didn't realize this was non-refundable or whatever. To the left of the box, it says application is not complete until page 5 is signed. And the reason it says that is because on page 5, the tenant's signature gives us the authority to run their background check, take a look at their credit, inquire with current and previous landlords, employers, etc. And frankly, it's also a release of liability for doing those things. So when someone brings the application in person, our reception coordinators will always make sure that they've signed page 5, as well as initialed all the other pages of this application as well. And it says unless this application is initialed on each page, it will not be processed. If more than 2 persons are applying, use additional applications. So the next thing it says here is the property address. An application is property specific, so they need to write in the address that they'd like to rent. Other agent information. This is whoever is representing the tenant. I hate the fact that it's referred to as a referral company. I think that the choice that LVR made to call it a referral company is leading to the confusion over these rental transactions. Most of you probably have no idea what I just said. That's okay. We're going to get into that later. But nonetheless, the referral company is the company representing the tenant, as well as the agent's name, public ID, license number, and the MLS number of the property that they are applying for. The next section here is the financial anatomy of the rental application. And as you can see, there are many places here where we can construct how and how much we wish to pay for this rental property. And just for a moment, I want to mention most real estate agents, and I guess most of the public also, for that matter, probably understand that, if you see a property listed for sale, you can offer list price, you can offer more, you can offer less, right? It depends on the number that they're asking for. It depends on how bad you want the property. It depends on whether there's competition and other factors as well. So the same is true with a rental property. I'm not sure why most agents don't understand this, but when it comes to filling out a rental application, the tenant is free to propose any rent they want. They can offer more rent, let's say in a competitive situation, if they really want a property, or if the vacancy rate is very low, like it is in our area right now. They can offer less. Maybe the property's been sitting on the market for a while, there's really no bites on it, maybe there's a lot of available inventory, or they can offer right at asking price. But understand, if you offer right at asking price on a rental or on a purchase, really nothing stands out about your application, your offer, right? So just a thought for you. And keeping that in mind, the same negotiating strategy would apply to the security deposit and all of these things. We don't have to copy verbatim what we see in MLS, basically what the property manager is asking for. We can offer anything we want. The first section there, rent from some date to some date. This is a chance for us to say that we're prepared to pay in advance. Let's say rent from the first of the month to the end of whatever month, or some sort of a partial month or whatever. And however that rent calculates out, that amount is going to go to the right of the dollar sign on that first line. The second line is the security deposit. So remember that Nevada law caps that at 3 times the monthly rent. But again, if you've got an applicant who maybe feels their credit is not strong, or they're relatively new on the job or new in the area or whatever, they have every right to put more security deposit here than the amount being requested in MLS. It's only going to make their application look more sincere. It's going to make them look stronger. And conversely, they could offer less as well. And then we have spots for key deposit, key fee, application fee, pet deposit, pet fee, cleaning deposit, cleaning fee. And then comes one for additional security. I know that term is vague, and I think it's vague by design. It would allow a tenant to come up with some creative way to provide more security. Now, not security deposit, but more security. A slightly different meaning of the word security, right? In other words, more comfort to the landlord. We can put up additional security by maybe coming up with any other fees or deposits that we wish to use here. Basically putting more money on the table, showing how earnest, how sincere that tenant may be. Utility proration, sewer trash proration, because in some cases tenants pay for those utilities on top of the monthly rent. So this is a chance for us to get those fees in there. The next one is prepaid rent. At TR Realty, we have some tenants who prepay their rent. We have examples, some military personnel. They know they're going to be gone for a while. They might choose to prepay a few months' rent. We have other people who prepay rent at the time of move-in. We have business tenants as well. And sometimes we have people who don't have a lot of verifiable income. So to provide security, if you will, to the property manager and or property owner, they're willing to prepay. We even have some tenants who pay for an entire year's worth of rent up front. We do have some known people, I don't want to say famous people, but some known people as tenants who just don't want to be bothered keeping track of that. They may travel, so they like to pay the rent in advance. And again, this is another way that you can show how strong you are as a prospective tenant. And then there's a section for prorated rent. So if you're moving in on a date other than the first of the month, how much prorated rent are you willing to offer? And then there's some blank spaces for anything else that may be germane in this case. There's a place for total. And then it says, please note that any and all rent, deposit, or fee amounts are an estimate, and the amounts identified in the lease agreement shall be controlling. Well, I think the biggest thing they're talking about here being an estimate is probably the prorated rent, right? Depending on how long it takes to get the application processed, the lease signed, maybe clean the property and get the tenants in, would probably adjust that calculation, much as the COE in a sale, the close of escrow date, affects things like tax prorations, HOA prorations, interest rate that's collected by the lender, etc. Then we go on to the applicant information, and the very first thing here is the proposed move-in date. This is more than just a date. I actually want you to put some thought into this, and here's why. I'm not saying it's the right thing to do, But I just want you to know that the move-in date can have a big effect on which tenant is selected, which tenant is approved. Why? Well, property managers earn an income typically based on a percentage of the rent. If there's no rent, there's no income. If there's no income, typically there's no management fee either. So it is in the property manager's best interest to get someone into that property as soon as possible. They're going to make the argument to you that it helps the owner, and it certainly does. The sooner we can get a tenant into the property, the sooner the owner can start collecting rent as well. Okay, so I don't want to say anything negative. It's a win-win situation if we get the tenant in the property early, right? I have seen many cases over the years where a property manager will select one tenant over another based on the move-in date, even when the tenant who wishes to move in later has maybe better credit, maybe a more stable job, they earn more money, that sort of thing. There's a trade-off there. What you have to understand about rental applications is that the person to whom you are applying works for the landlord, or in some cases is the landlord. And just like a real estate agent who represents a seller, there's no first come, first serve. If you represent a seller, it is your job to get the best purchase price for the seller, right? Best terms, conditions, closing date, etc. Well, the same is true with applications. There's no first come, first serve. If there's more than one application that comes in within a short period of time, not only does the property manager or owner have the right, but you could say they have the obligation to compare those, to get the best possible tenant into that property for the owner. And proposed move-in date, which generates revenue sooner, is a very important part of that. So if you're working with an applicant, and that applicant really wants that property, they should probably put the move-in date as soon as possible. It's definitely going to make this application more attractive to the property manager. And after that, it goes on to talk about the applicant's personal information, date of birth, driver's license, email, etc. Don't forget the initials down the bottom of the page. Page 2, address information, employment information, personal references. On page 3, it says, please identify any and all co-applicants. And then underneath that section, it says in bold print, for privacy purposes, all co-applicants must submit their own individual rental application. Well, maybe. If the co-applicant is a spouse or a partner or a family member or someone that the applicant is close to, they might not want to keep their information private. They don't have to go through the hassle of doing a separate rental application. So if they're okay, putting their information out there for their applicant, their co-applicant, I should say, to see, then you can absolutely go ahead and use this section and not do a separate rental application. Continuing on page 3, there's vehicle information. There's a section for other occupants. So this is going to be anyone who is a non-responsible person who will be occupying the property. And this would even include, a 2-month-old baby. We have to list all occupants on this application. It's really important. And then near the bottom of page 3, we come to a kind of a difficult section where it says pets. And notice next to the word pets, you already see an asterisk there. It's because this is a little tricky. This has changed recently, and I want to make sure that everyone watching this video understands the correct way to handle this section. And it says if you have a service animal, emotional support animal, or assistance animal, as those terms are defined, your animal is not a pet. It says stop. Yeah, it literally says there, stop. Please fill out lease addendum for service and/or emotional support animals, collectively called assistance animals. So again, this section has changed. Listen carefully to how we should be handling this. It says pets, yes or no. If yes, please complete the following. So there used to be a separate pet application. Now, we're going to go over that application shortly, but that application is no longer used at the time of the rental application anymore. That application is now only for those who wish to add a pet later during the term of their occupancy. Now, if the tenant wishes to move in with a pet, we don't need that application. We fill out the information right here. But when you look at this section, it's asking for the name, age, breed, weight, gender of the pet, whether the pet was neutered, and even the license number. Yes, pets need to be licensed. It doesn't mean everybody follows the law, but pets do need to be licensed. And if you have a pet, you need to have that prepared. So if you're a real estate agent watching this video and you're working with a prospective tenant, it would be prudent to talk to that person in advance and let them know if you're bringing a pet to the property, there are certain things that are going to be required that we have to submit right on or right with the application. So we need to think about these things right now. Let's look at the top of page 4 and you'll know what I'm talking about here. It says applicant certifies the landlord that the pet is in good health, and as proof, therefore, a certificate of good health from a licensed veterinarian is attached. Is attached to this application, which is one reason we need to be prepared in advance. We can't fill out the application and then start scrambling to contact a vet, get a license number. It even says here, in addition, a clear photo of each pet is attached to this application with the pet's name on the back. And there's other information that needs to be read here and digested about pets, but I want to bring your attention down to number 8, which talks about insurance. Applicant shall obtain an insurance policy that includes pet coverage. So yeah, folks, if you're bringing a pet into a rental property, it's a big deal. You need a certificate from a vet. You need a license number. You need a photo, and your insurance policy has to include pet insurance as well. So again, that's why I say we educate our prospective tenants up front. We make sure they're prepared for the application process. Continuing with page 4, other information about bankruptcy, about eviction. Has the tenant ever willfully refused to pay rent? How long does the applicant plan to live here? That's a great question. What do you think is more attractive to a property manager? Someone who says they intend to live on the property for 3 months, or somebody who says they intend to live there for 5 years? Which do you think would be more attractive, right? Now, there's nothing legally binding about this question. It uses the word plan, right? I plan to love you in the morning, right? So, it's just an interesting question that can be used to further create the impression that this is a solid, serious, stable tenant who wants this property. Does applicant plan to use liquid-filled furniture? I'll let you make your own joke about that one. And then it says, does anyone in the household smoke? Yes or no? And this now includes, but is not limited to, the use of tobacco, smoking-related products, electronic cigarettes, vaping pens, or other instruments that cause smoke. Guess what, folks? Smokers are not a protected class. And a landlord or property manager has every right to say this is a non-smoking property and then subsequently enforce those rules as well. So, yeah, you could be denied housing because you smoke. And you don't want to lie here, because if you lie, chances are your security deposit is going to be forfeit. And in addition to that, you could be responsible for any other damage to the property. There's emergency contact information at the bottom of page 4 as well. Moving on to page 5, please read carefully before signing. Applicant understands that blank is the leasing agent and representative for the landlord. So that's where we put in the property manager's name or the courtesy listing agent representing the landlord. Of the premises located at, we put the address again here, at a monthly rent of, and we fill in whatever rent is being offered. Number 2, applicant declares that the information contained herein is true and correct. An applicant authorizes an employment check criminal records check, credit check, verification of references, and current and previous landlords. Number 3, applicant hereby pays blank as a non-refundable application fee and blank as a holding fee. Holding fees, or sometimes called holding deposits, are sometimes used. We don't really use them much at TR Realty, as I mentioned, but they kind of work like EMD in a purchase. So paragraph 3, we have to fill in that non-refundable application fee. Number 4, applicant agrees to execute a lease agreement before possession is given and to pay the rent and security deposit within blank business days after being notified of acceptance of this applicant. Typically a couple of days, really not much more than that, because if the tenant is approved, he needs to pay, the balance of his money, security deposit, rent, whatever, and needs to get that lease signed. The tenant cannot expect a property manager or owner to keep that property off the market waiting for him very long. We need to consummate this transaction now, collect the fees, and get the contract signed. Number 5, landlord and agent will not be bound by any representations, agreements, or promises, written or oral, made by landlord or agent unless contained in the lease. So what this is saying is that the lease is going to supersede anything else. The lease is going to supersede this application, and it is certainly going to supersede any other communications, emails, texts, phone calls, or verbal communications as well. Number 6, applicant has reviewed the public record information on the Clark County Recorder's website. Oh, I don't like this one. The reason this is in here is because I think a lot of us watching this video would probably agree it wouldn't be a very ethical thing if we put a tenant into a property that was in some state of foreclosure, right? Because now you could create a situation where the tenant is doing the right thing, paying the rent, setting up his home, in the new property, and all of a sudden the constable comes knocking on the door. Guess what? It's time to be evicted. The property has gone to foreclosure. We don't want that to happen. And, some might make the argument that there's liability on the real estate agents involved in putting a tenant into that kind of property. I'm not an attorney or a judge. I can't say if there is or isn't liability, but I could tell you to stave off the potential for that liability, LVR has created this paragraph shifting the onus to the tenant, basically telling the tenant, it's your responsibility to go to the recorder's website and, check that website if there's any summons and complaint or notice of default filed against that property, either of which would indicate an imminent foreclosure. So I don't think that's very good, but nonetheless, it's in there. I guess it's protection for the real estate community. I guess I should be happy about that. But anyway, it is what it is, right? Paragraph 7, applicant does hereby release landlord, agent, and this company from any and all damages or liabilities which might result from the above information. Number 8, applicant understands and acknowledges that a false statement made herein is grounds for denial of rental to applicant. So can't lie on your application. Number 9, approval for residency is made without regard to race, color, religion, etc. Absolutely. We are strict adherents to fair housing. And number 10, applicant understands that applicant acquires no rights to premises until execution of a lease agreement in the form submitted and deposit of rent and security described above. So until you pay, until you sign, you can't get into the property. The applicant needs to sign, date, time, and print here on page 5, not to mention the initials on the bottom of the page. And folks, that is a standard rental application. That is the one that is used at TR Realty, unless the tenant wishes to apply online. So we actually have an online version of our application as well. And of course, since we are a green company, we don't want the paper. We don't want, a paper money order. We don't want people driving across town to submit their, application in person. We do encourage people to go online and fill out the rental application. They can do it 24/7, especially in the days of COVID, where we are right now. They don't have to go somewhere. They don't have to meet somebody. They can do it from the comfort of their own home. They can pay their application fee with a credit card or a debit card, although there is a $3 convenience fee that the system will charge the applicant to use the credit card or debit card. But no more paper applications, no more money orders, no more driving around. We just got more green with this. So please encourage, whenever possible, to do the application process online. And therefore, if you are a property manager or a courtesy listing agent watching this video, when you put a property into MLS, you need to include the following link where prospective tenants will go and submit their application and pay their application fee. Get ready to write this down. The link that needs to be in all MLS listings at TR Realty is www.thetrteam.com/apply. Again, www.thetrteam.com/apply. I want to circle back now and get into the lease addendum for assistance animals that was referenced in the application itself. It's our next handout. Please go ahead and get that in front of you right now. It says at the top the property address, so that is the address that we are intending to rent. It says, pursuant to this lease addendum for service and/or emotional support animals, collectively called assistance animals, the landlord or owner may permit a tenant with a disability to keep an assistance animal as a reasonable accommodation, provided tenant agrees to the following terms and conditions, which upon execution become part of the tenant's lease. Please initial next to each item below. All right, I stress the word lease because if you look at the title of this form, it is a lease addendum. So if and when we do a lease on the property with this tenant, this form actually becomes an addendum to that lease. It says, please initial next to each item below. Number 1, tenant certifies that he or she is disabled. And tenant acknowledges that his or her assistance animal is necessary to allow him or her the opportunity to use and enjoy the dwelling. Number 2, in order to comply with federal and state law and obtain permission to keep an assistance animal, tenant must make a reasonable accommodation request for such an assistance animal to the owner or manager. Any reasonable accommodation request will be granted unless one or more of the following. The assistance animal may not pose a direct threat. The assistance animal may not cause substantial physical damage to the property. Tenant understands and agrees that making the requested accommodation would pose an undue financial and administrative burden or fundamentally alter the nature of the provider's operations, or a determination that an assistance animal poses a direct threat of harm to others. So if none of these 4 conditions would apply, it is expected, because it is the law, that the property manager and owner grant the assistance animal to occupy the property, grant permission for that assistance animal to occupy the property. So again, the law does require that reasonable accommodations are made. And this paragraph attempts to lay out those reasonable accommodations. Paragraph 3 says the fact that a person has a disability does not automatically entitle him or her to an assistance animal. There must be a relationship between the person's disability and the need for the animal. Number 4, the following rules apply with respect to assistance animals. No deposit or fee will be assessed. However, tenants are financially responsible for any injury to persons or property. Tenants are responsible for the disposal of waste. Tenant will keep current with the animal's immunizations and provide evidence of such. If local laws require animals to be licensed, then tenant will do so and provide landlord with evidence of such. Tenant will not allow his or her assistance animal to become a nuisance. All assistance animals must be properly restrained when outside, and must not be left unattended when outdoors, and again, restrained. I'm not sure why the language repeats there. This is an LVR form. We can't change their form in any way. Number 5 says the term of this lease addendum may be amended pursuant to further reasonable accommodation requests made by the resident. Number 6, it is agreed that the foregoing provisions are necessary components of the reasonable accommodation that is the subject of this addendum. Non-compliance with this addendum constitutes a material breach of the tenant's lease agreement and may authorize remedies for violations provided in the lease up to and including eviction. So bottom line, folks, if you have a service animal or assistance animal, don't lie, don't provide fraudulent paperwork, don't misrepresent, don't commit fraud. There are plenty of people who need service animals, who need assistance animals, legitimately need them, and we don't need to sully the concept with people committing fraud. So that is, in essence, the lease addendum for assistance animals, which the tenant needs to submit. However, I just want to be clear that there's no law that can compel or that compels the tenant to even do this lease addendum whatsoever. This is all about the real estate side. It's all about trying to lay out the rules for the tenant. But I want to reiterate that if someone has the legal right to have a service animal or assistance animal, it cannot be restricted in any way, okay? So I just want to put that out there as well. And next, I want to get to the application for pet approval. So go ahead and get that in front of you now. This application for pet approval works very much like the section in the application that I went over in this video series, where it is asking for the name, the age, the breed, the weight, the gender, license number, and whether the pet is neutered. It's asking for a certification from a vet that the pet is in good health. It's asking for a photo of the pet labeled with the pet's name. It's asking for proof of pet insurance. So basically, this used to be the standalone form that had to accompany the original application for a prospective tenant. What LVR did, which I think was smart, they took the information off this application and put it right into the original application itself. And what that means is this application has been rendered unnecessary for move-in. It is not necessary to be used in conjunction with a rental application anymore. This should only be used when a tenant wishes to add a pet later, when they've already signed the lease and at some point later they're going to add a pet to the property. That's when we go back and we do this application for pet approval. Okay? I want to be very clear about that. If you ever give your customer a rental application to take to another real estate company, which you shouldn't do, by the way, be sure to write your name on it and your license ID number, not your public ID anymore. We use the license ID number now. Write it right on there. I wouldn't like paperclip a business card or anything, which could fall off. But your name and license number right on the application. And the reason I said you shouldn't do that, you should go for them. I mean, you're representing this person, and not only is it good service for you to submit the application on their behalf, but something that really bothers me personally is when property managers say they need to see the applicant in person. Why? What is that? What are you looking for in person that's not on paper? Are you trying to see their race, maybe, their color? I don't think that's really good. I think that is a backdoor attempt at discrimination in some cases. So I don't believe in that. I don't think there's any reason that the property manager needs to see or meet the applicant in person. It's another reason why I think the real estate agent representing the tenant should go ahead and get that application submitted, or in more and more cases, like is the case at TR Realty, the application is actually done online now. There's no personal interaction. And by the way, if you are a property manager or a courtesy listing agent or even a property owner watching this video right now, be smart. Don't meet the applicant in person, okay? Because if you have to deny that person, and that person turns around and says, oh, you denied me because I'm this color, this race, this religion, this marital status, this gender identity, or whatever, you're gonna have to defend yourself against that. And even though you might be right, even though you might not have discriminated against that person, there might be a legitimate reason to deny them this particular housing, you are going to have to defend yourself, which is going to be time-consuming, expensive, and a pain in the ass. So avoid that whole thing completely, and do not meet the applicant in person so no one could ever accuse you of discrimination, okay? If a property manager has the application online, like we do at TR Realty, you probably want to help your customer to fill out that online application together. Not everybody speaks English as a primary language. Also, it can be long, it can be overwhelming, it could be tricky. Work with them. And also, from the real estate perspective, sometimes the rental application has a simple question. Are you working with an agent? Are you represented by an agent? If they don't fill that question out, or if they forgot your name or they forgot your company or whatever, and they just leave it blank, it might be a struggle to get paid commission later in that transaction. So another reason why, if you are an agent and the application process is online, you probably want to sit with your customer and do it together to make sure that your information is included. This kind of circles back to something I was talking about a minute ago regarding submitting the application on behalf of the prospective tenant rather than having the tenant do it themselves. I would also be skeptical when a property manager asks for a copy of the tenant's ID. Honestly, I recommend redacting the photo. If you're not familiar with the word redacting, it just means striking it out. Again, if someone like a property manager wants to see ID, they want to verify someone's name, they want to verify their driver's license number or whatever, they have every reason, legitimate reason to do that. But why do they need to see the photo? That troubles me because I've been in this business a long time, folks, over a quarter of a century, and I've seen a whole lot of stuff going on out there that I'm not going to talk about right now. But if I were representing a tenant and the property manager asked for a photocopy of someone's driver's license or passport, I would absolutely instruct them to redact that photo. And if that property manager ever challenged why that photo was crossed out, why that photo was maybe covered up, let me tell you, they're going to have a hell of a battle with me, because I can't think of any legitimate reason why, before approving a tenant, they need to see what that tenant looks like. My opinion. Now, at TR Realty, obviously, we charge application fees, as does every company that I know of anyway. The application fee, as I mentioned earlier, is for the cost of running the background check and processing the application. There's a real cost there. And let me tell you what those fees are at TR Realty. The first adult is $69. Any other adult is $30 as long as they are on the same application, okay? $69 for the first adult, $30 for each additional adult on the same application. Those fees are non-refundable. We are going to check their credit, their criminal history, their eviction history, and their employment history. And I want to be clear that these are application fees at TR Realty, meaning a TR Realty listed property. I can't tell you what the application fee is going to be at XYZ Realty or JFK Realty down the street, okay? So if the tenant is applying for a property that is managed or listed by TR Realty, those are the fees right there. There's something that we do at TR Realty that I'm not aware other companies do at all, which is upon request, so you have to know this, which is why I'm telling you now, we will roll over the application fee for a prospective tenant who was denied for 30 days so they can apply for another property. Now, sometimes an applicant is denied just because, we received 9 applications in 2 hours for the same property. Obviously, we can't take 9 people for the same property, right? So 8 of them are going to be denied. Sometimes there's nothing wrong with somebody's credit, with their employment, with their background. Everything is fine. It's just that somebody else was a little bit stronger for some reason. So as a courtesy, so that someone wouldn't have to pay us another application fee, we will roll that over up to 30 days if they turn around and they apply for another TR listed property. As a backup, a TR Realty associate can process a rental as a referral. It's still better to do it as a rental. I know this is confusing. Let me try to explain a little bit here. So if we go back in ancient history, in the market here, in the Nevada market, sometimes property managers would simply ask a tenant's agent to refer the applicant to them, and they would take over from there. That is old school. That's not how it's done in most cases anymore, or should be done, in my opinion. I believe the tenant should have their own true representation, which is why when we went over the forms earlier in this video series, I talked about the duties owed, the consent to act, which is why earlier in this video series I talked about the duties owed, the consent to act, because I believe we want the concept of representation. I mentioned earlier also that there's controversy whether a real estate agent should even do a duties owed in a rental transaction. And I told you at TR Realty, I want my associates to do a duties owed. And I just want to try to explain my position on this, because I think out there in real estate today, this is about as clear as mud. But let me try to tell you where I stand as a broker. Now, first of all, the duties owed form needs to be done as soon as practicable, right? As soon as we can possibly get our customer to acknowledge the duties owed by signing it, we want to go ahead and do that. Well, great. I understand. I am in full adherence and compliance and understanding of that. When we go into MLS and we search for properties, what we see offered to us is a cooperating commission. We do not see anything that says referral fee. We see a cooperating commission. And cooperating commission should tell you that there's another broker involved. There's representation involved. And we wouldn't know until the very end or close to the very end if that property management company representing the landlord is going to treat us like a referring broker or is going to treat us as representing the tenant. Sometimes we just don't know. In fact, usually we just don't know. There's nothing in MLS that tells us that. So if the real estate division's position is that we need to do the duties owed as soon as practicable, and in MLS it says cooperating commission, it doesn't say referral fee, I'm going to stand by my position that we need to do the duties owed every time in a rental transaction. Now, if we don't need it later because it turns out that the property manager is treating this as a referral, fine. I would rather have a legally required form in my possession that I don't need than to find myself in a position where I need something that I don't have. I think most of you would probably agree with that. So that's why I say there's confusion whether we process a rental as a rental or we process a rental as a referral. By the way, I don't see this confusion going on in any other state. I hope that the real estate division can stand up and, state their position, maybe issue a white paper in this regard. But this has been going on as long as I've been in real estate in Nevada. So we have on our Broker Mint site, we have the ability for an agent to process a rental as a rental or process it as a referral. And by the way, in my most recent communications with the real estate division, they say that what determines whether this is a rental or whether it's a referral is the confirmation of representation section in the lease. In the confirmation of representation section, if the tenant's broker is listed, it is clearly going to be a representation, and therefore duties owed is going to be required, right? It's called confirmation of representation. For me, that's about as clear as it can possibly get. But if you allow the other broker, the property manager, or the listing broker, courtesy listing broker, to put in his own information representing the landlord and representing the tenant, that, in my opinion, is the only scenario where that broker can now call this a referral, my opinion. Either case, you can process it at TR Realty as one of our agents, okay? I would also make sure that you get credit in MLS, because after all, MLS is a sharing service. It is offering a cooperating commission. If you bring the tenant, you are entitled to get credit in MLS. It should not be the listing agent or the property manager who is getting the credit for procuring the tenant. It should be your name down there as well. If I were you, I'd follow up a few days after lease signing and make sure that you get credit in MLS. Sometimes when you're working a rental or referral transaction, the other side is going to request a TR Realty W-9. We have that available on our website. Please don't reach out to the office and ask us to send it to you. There's no reason to do that. You can just take it off of our website. Now, everything that we've been talking about in the last while here is paperwork that is required on the lessee's side of the transaction. I want to go back now and talk about the paperwork that is required on the lessor's side. So in other words, if you are representing the landlord as a courtesy listing agent, here is the paperwork that you're going to need. Very simple. Are you ready? Number one, you're going to need the duties owed. Number two, you're going to need the consent to act, and that will allow you the opportunity to also show that rental property to prospective tenants. The only time you wouldn't need the consent to act is if the landlord says, no, I don't want you to act as a dual agent. I want you to only represent me. Then the consent to act is not going to be required. And third and final required form on the lessor's side is going to be the ER, the listing agreement, the exclusive right listing agreement that I cover in great detail in Class 4. It's the same one. It is not a different one for rentals in our association. So that is the paperwork on the lessor's side. Duties owed, consent to act, and the ER listing agreement. I would like to thank you for watching this video. I hope it was informative for you. If you are licensed with another brokerage in Southern Nevada and would like to talk with me, please text me or visit our website. See you next time.